If you are a law student working to improve your CGPA, there is no better way to begin than to master the art of answering problem questions. A lot of people often have issues with their legal studies, not because they are not intelligent, but most often, it often comes from the ability to navigate through law questions. So in this video, what we hope to achieve today is to use a practical examples to teach students, especially law students, on how to navigate through problem questions. On this video, we are going to analyze some questions using practical applications, IRAC, IPAC, IBC to answer the questions. So without further ado, let me give space to the screen so that we will be able to make use of the full screen and analyze our questions. If you are new here, my name is Kingsley Ifeanyichukwu. I'm currently a 400 level law student, and what I do on this channel is to help law students to be able to make a better grade and pass through the journey of being a lawyer. Let's go into the full video. Now, let's start with the first question. The first question, I'm going to read it out. So all of us will read it together. Of course, you can see it on the screen. Now, after reading it, like I said, today is a practical video. So after reading this question, we sift out the relevant point from the irrelevant one. I pointed this out in our first video. And second video, where I describe it as sifting the facts. It is a course or it is a topic in second semester, basically in legal method. So if you have not offered it, you will still see it. Your ability to sift out what matters from what doesn't matter. That is what sifting of facts means in its simplest term. Now, let's go to the facts. The fact says, and I quote, during a class Moots at Ambrose Ali University, 200 level law students, that is 2 students from 100 level, Halima and Toby, were selected to argue on a contentious point involving a land inheritance dispute in Kogi State, Nigeria. Mark that word, Kogi State, Nigeria. Toby, arguing for the claimants, based his argument entirely on a customary law practice of the community that give lands to male children. He insisted that custom is law. The court must uphold it. Let's mark this word. We say Toby, arguing for the claimant, based his argument entirely on a customary law practice of the community that give land only to male children. He insisted that since custom is law, the court must uphold it. Halima, for the defendant, opposed his submission by citing a provision of the 1999 Constitution along with recent judicial authority that prohibits the discrimination based on sex. Let's keep noting down relevant points here. If I'm you, I'll just pick up my pen and jot and put down some keywords. There are some certain keywords here which is worthy of note. We talk about the Kogi State, showing that this thing is happening in Nigeria. We'll still come down. We are not done with the fact of our case, but I'm just telling you to follow me. So write down Kogi State, which borders that this matter is coming from Nigeria. Now, we also note down the customary law practice of the community that give land to male children. You also note down he insisted that custom is the law. So underline these principles. We'll continue. Then coming down to the third paragraph, we also have Halima, for the defendant, oppose his submission, yes, by citing a provision of the 1999 Constitution. Note the particular law he cited. Note it down. Along with recent judicial authority, that means he has cited the 1999 Constitution and also a recent judicial authority, which means that he cited statutory authority and what? Judicial authority. That is what he has ended up citing. Furthermore, to strengthen her position, she referred to a passage from Professor Bin Laden's book on Nigerian legal system, which supported her view. So I believe we can now see that he cited the 1999 Constitution, which in this case we regard as what? Primary sources of law. He cited again judicial authority, which in this case we regard as what again? Primary sources of law, sorry. So We cited another thing, which is Professor Bin Laden book on Nigerian legal system, which is regarded as what? I will allow you to answer that. So let's just continue. In response, that means Toby, the appellant, is now countering, or the plaintiff is now countering the argument again. So as we can see now, a counter of argument is currently what? Ongoing. He said Toby dismissed the book, claiming it to be a merely an academic opinion and does not hold the court. So Toby, in his counterclaim, dismisses the book, alleging that it is nothing but a mere opinion which should not bind this court of law. He seriously maintained that since the community had followed the custom for generations, the court had no business in interfering with it. So Toby is trying to drive the court persuasively by telling them, please, you should discard this thing, that this is merely academic opinion. Perhaps we could also see that this custom has been followed by the community for years. So my lord, don't touch this case. Allow this authority of the custom to stand. Now we'll come to the lecturer's question. As a law student, you are to advise the class based on the principles of legal authority, sources of law, and the binding nature of what each student has relied upon. Very important. Now, before we continue, I would like you to know something. That's why I would definitely encourage you, if this is the first video you are coming across on how to answer problem question from this channel, King's Advocate Network, I'm encouraging you, once you are done with this video, click the video you are going to see next, because it will help you to understand everything I'm going to say at this point. I'm not going to repeat myself because it will make this video long, especially for them that have followed us from part 1, part 2, and now on part 3. So what am I trying to say? What I'm trying to say is that we have made so many explanations as regard to our role in problem questions. Sometimes we are meant to be a lawyer, sometimes we are meant to be a judge, then some other time we are also meant to be advise the parties. Some other time we can be the director or AG of the federation or AG of the state, the prosecutor. In this case, looking at this thing, the question says, like I say, this question was directly from the lecturer. He said, as a law student, you are to advise the class, now not the parties, but the class, based on the principles of legal authority, sources of law, and binding nature of what each student have relied upon. In other words, you are meant to be a judge here. Yeah, you got me? That means your purpose here is to be the judge in this case. You are now advising the class. You are reading your judgment to the class based on the authority cited. The parties here are what? Key players. They are the lawyers. You are not meant to be lawyer here. You are meant to be the what? The judge. And in our previous video, I also told you people concerning how this problem question works. That sometimes what you may be required to do could be, the question given to you could be open-ended. Sometimes it will not be open-ended. Looking at this one now, you will see somehow that you have been given a role to play actually, but as a judge. So to do this as a judge, just like as a judge delivering his judgment, he's going to frame issue, isn't it? In all the judgments, you will see that lawyers will frame their issue before the court. But sometimes lawyer could even frame their issues to be 10. But the judge who will read the judgment will reduce the judgment, particularly the person to read the lead judgment, might reduce the whole 10 issue to 2 based on what he deems necessary. As lawyers, clients have come to your case with your chamber and said a lot of things. Then you sifted out of the relevant facts and then approach the court. When you get to the court, on the other hand, the court will also scrutinize your own submission as counsel and then sift out their own facts from your own and discard the irrelevant issue you have framed. So that is what we are going to basically do. Remember, problem question is basically what you do in the court. They are training you. So we approach it the way I have said it. How do we begin here? Let's remember our previous video. We have IRAC, we have IPAC. Let's just adapt IRAC in this case In our next example, we are going to go with IPAC. So first and foremost, what are we going to do as a law student? What we are meant to do here is to identify the issues. While doing that, you must make sure that you identify as many issues as possible. Remember, issue cannot be exhausted, but what you are just required to do is to note down the relevant ones. That's why you see some students framing different issues from different questions. It all comes to your ability to understand, your level of knowledge of the law, and then your level of knowledge of the facts. These are the things what makes you or gives you issue. So let's frame our issue. The first issue now is whether the customary law relied on by Toby is binding and enforceable in this case. So under this scene, let me just continue so that after we analyze the issue. Now, the second issue is whether the constitution and judicial decision relied on by Halima override the customary law. Then the third issue is whether a textbook or academic opinion like the one cited by Halima has a binding authority in the court. So I have successfully identified 3 issues from the facts before us. So now, starting with the first issue, is customary law binding in Nigeria? What are we doing? We are applying IRAC. So remember what I told you, you don't go and say IRAC or IPAC. We have identified our issue. The possible thing you could do is just to identify your issue. Once you have identified your issue, you are good to go. So where we are heading now is the rule and the application. And I told you people in that previous video that rule and application goes hand in hand. There is nothing different from rule and there is nothing different from application. Once you can either, application simply means marrying the rule with the facts. So let's continue. Now we begin. We said we have asked ourselves, we have pointed out the first issue, ready to address it. Now we begin the application. You can start from the point of law by saying according to, or you can start from the fact and proceed to the law. So let us begin. Yes, customary law is recognized as primary source of law in Nigeria. We have underscored that customary law is recognized as what? Primary source of law in Nigeria. Because it reflects the tradition and the cultural norms of the various community. And where it is not repugnant to natural justice, where it is not repugnant to what? Natural justice, equity, or good conscience, it can be applied by the courts. So are you getting the point now? We are answering this problem already. We have moved from issue to the what? To the application. And I told you you can start from the fact and proceed to your rule. So we have identified that customary law is a source of law. So now we move. So, however, for any customary law to be binding, it must satisfy 3 tests. We are pointing the law here. We are marrying the law with the facts. So it must pass through tests, the repugnance test, the incompatibility test, and the public consideration or public policy test. So this was clearly emphasized in the case of Owoyoni and Omotosho. It was in the case of Owonoyi and Omotosho that the court illustrated this principle that for customary law to be binding, it must have passed through the 3 doctrine tests. And once it has satisfied this test, the court is bound to apply it. Also, in the case of Mojeku and Mojeku, the Nigerian court also stated that custom is law and enforceable, provided that it doesn't go what? Contrary to the constitution. And once it has passed through constitutional scrutiny and become morally upright before the constitution, it is what? Applicable. What have we done here? We have stated the law. Which law did we state here? We stated judicial authority. I told you in the part 2 that authority could be statutory or judicial. So if we talk about citing authority, these are what we mean. You are seeing it happening every time before us. So we proceed to the second issue. As you can see, we have answered the first issue. Now the second issue says whether the customary law override the Nigerian constitution or judicial decision of the higher court. That is our second issue. So the answer is clearly no. We are going to the what? To the application. The answer is clearly no, because by virtue of section 13 of the 1999 constitution as amended, any law including custom that is inconsistent with the constitution shall be void to the extent of its inconsistency. What have we done here? Can somebody, the law outside here, tell me on the comment section what we have done here? The authority was cited here. We have applied the rule, right? Not only that we have applied the rule, but we did what? We applied statutory authority. So when the lecturer say using relevant authority, these are what they mean. And now, what are we doing? What is our role in this problem question? Our role is that of the judge. Typically that of the judge. I told you people in our part 1 that you could be a lawyer. You could be playing a role of an advocate. You could be playing a role of what? An observer. It could be the party to a case. Then they are advising you. So we are playing the role of what? A judge, telling the class the bindingness of this authority. We are delivering our lead judgment. And to deliver our lead judgment, we framed issue. And we are in second issue. We say that custom cannot override the constitution because any law that is inconsistent with the constitution, to that extent, is null and void. Section 11 of the 1999 constitution as amended. To garnish our work, we go further to the case of Mojeku and Mojeku. Relying again on what? Which authority are we relying again? Can you tell me in the comment section? Which authority? I have said statutory authority. This one now I pointed them Mojeku and Mojeku. Please tell me the authority we are relying upon here. The types of authority it falls under. I want to know from you in the comment section. So the court ruled that a customary law which excludes women from inheriting property purely on the basis of gender violated section 42 of the constitution and was thus what? Unconstitutional. Which authority have we cited here once again? To support this further, the court Pameri or the JLC as then what? In the case of Ukeje and Ukeje, stated it again that any law or Igbo tradition that discriminates against women to that extent is null and void because of its inconsistency. Are we making points? Are we getting the point we are making? So, another thing I wish to tell you is that whenever you are writing problem question, make sure the authority you are citing, you are relating it to the fact in question. For instance, I cited the case of Ukeje and Ukeje. That case emanated from Anambra State, Nigeria, which is southeast, falling under Igbo tradition. But the fact before us has it that it is originating from Kogi State, possibly from Igala. I don't know many languages in Kogi State, but I know one, Igala, majorly dominates Kogi State. So what are you going to do? You are going to make the case of Ukeje and Ukeje relatable to the fact. Now let me give you a practical example. Therefore, we could say that the custom cited by Toby, even if widely accepted in Kogi State, cannot override the constitutional provision guaranteeing equal rights to both sexes. So if that's why I told you from ab initio to note down Kogi State, because the place the action happened is very, very material. Pay attention. If your lecturer are giving you something that happened in the north, for instance, if you're a criminal law student watching this video, you should be able to know that not everything that applies in the southern part of the country applies in the northern part of the country. You should know that penal code should apply, not the criminal code. If they're asking about adultery and whether adultery is a crime in the southern part of the country, you should know that adultery is not a crime in the southern part of the country. Don't use your personal bias or personal background to imply into the law. The law must be remain pure. So the law here is we have applied the case of Ukeje and Ukeje. Even though that Ukeje and Ukeje didn't happen in Kogi State, it is still applicable here because Kogi State is still within the purview of the 1999 constitution. And besides, the interpretation of Ukeje and Ukeje was purely based on section 42, which borders on the right to this freedom from discrimination of the 1999 constitution. The court just buttressed a point. So are we getting the point? If you are getting point, tell me in the comment section. If you are not, tell me so that I will amend this video and choose it in a way that it suits your understanding. You can also ask your questions because this is just third video. We will continue to analyze problem question until all of us viewers get to know problem question. So we are not stopping for me. If you have question, ask it. Once I come, I will make another video that explain it better for you. So let's continue. Now let's continue by getting to the third issue. So we have come to the third issue. The third issue is what is the legal right of textbook by Professor Bin Lade. Remember where we are coming from. We are told these things are not what we are told. What we are told to do is to examine the binding nature of the authority with regard to sources of law and all those things. But to do that, because we are told to explain to the class, and I told you our role here from the implication of what we are told to do by our lecturer is to play as a judge. We are delivering a judgment to the students. We are not a party. We are not lawyers. They have submitted. We are delivering a judgment. And as a judge, you are delivering a judgment on point of law, not I think, according to me, who are you? You are delivering your judgment based on law. That's why if you go to law report, you see judges citing laws. With the one they cite, another judge, when another judge is delivering a matter that have similar facts with Ukeje, that judge will still quote Mary Odele. Mary Odele quoted another person, and the quoting continue till eternity. Our generation will continue to quote Barrister Kingsley Omen. Justice Kingsley Omen as then was said. Yes, now I will say one day in the future. I don't know for you. So if we continue now, we get to the third issue, which is the legal weight of Professor Bin Laden. Now, I want you to make an opinion here, because this one has more of, applying it. It is very applicable. Here now, you could just say something like this. I proceed to say to my lecturer, I proceed to say to you all the class, or to you my lecturer, that textbooks and writing of jurists are categorized as secondary source of law. Hi, is somebody following this lecture video? Are you seeing how we have arrived at answering that lecturer question, which specifically has to do with what? Identifying the categories of law. With this, we could just say that they do not have binding authority, but can serve as what? Persuasive authority. What we are just trying to say here is in furtherance of the issue 3. We say that whether a textbook or academic opinion, like the one cited by Halima, has a binding authority. And we are trying to make a point that it doesn't have a binding authority. It is more of persuasive only when the person quoted is an authority and it consolidates with already established principles of law. That is to say, it mustn't go contrary to the law. If a textbook went contrary to the law, whether it's coming from Professor Bu or whether it's coming from Professor Agoba or Agoda, it is immaterial. What matters is that textbook must consolidate the already established principles of law. Now, that will lead me to where that matters most, conclusion. I told you in my first video, part 1, on how to answer problem question, which you must watch. Yes, you must watch it after this video because it will help you to understand what we see. I told you that conclusion and issue are very critical area, which will determine or mar your mark. Sometimes the lecturer will only read the issues and go to your conclusion straightforward. So if you get your conclusion right, now is where the whole mark will be awarded. Issue could just go with 4 mark, conclusion could have something like 10 mark and above. That is where you must capitalize on. So in conclusion, having identified the key issue in this dispute, it is evident that Halima's argument is legally superior. Based on these reasons, she relied on primary binding authorities, the Constitution, and the judicial decisions, and further supported her reasoning with a persuasive secondary source. Toby's reliance on the customary law was misguided in this context, as the custom is inconsistent with the Constitution and cannot be upheld by the court. So this scenario teaches us the vital lesson in legal method. I don't know if you are following the point. The principles in legal method, if you have offered legal method up to 2nd semester, is that secondary sources are purely persuasive on the account of the author or the writer. And what are the secondary sources of law? We have made a video that dwells on that. Subscribe so that you'll be able to see more video when we post video here every single Saturdays and also Wednesday for short form video. Let's not forget, as a law student, the question given to you was specifically to do this. As a law student, you are to advise the class based on the principles of legal authorities, sources of law, and binding nature of what each student relied upon. To do this, you have to raise issue, because assuming you answer this question directly, you wouldn't have weighed side by side the whole argument. That is why problem question is problem question, because it makes you to think like a lawyer. You don't just answer it straightforward, but there are some which may not come with issue. That is why I'm telling you, if you have not subscribed to this channel, you are missing something that will help you. Next video, I'm going to tell you another example that you may not need to raise issue. Possibly, we may use contract law or criminal law. So I encourage you to check the video I pointed out. The 2 videos we have already made on this channel. Click this link above, this link on your screen. Now click it so that you watch that video. That will basically lead you to understand everything said here. And on my next video, I may be using contract law or criminal law or possibly evidence law to illustrate another problem question.